Welcome to a special episode of International Law Chats, a podcast from the American branch of the International Law Association. I am Chiara Giorgetti. I'm a professor of international law at Richmond Law School and a senior fellow at the International Claims and Reparation Projects at Columbia Law School.
And I'm Alison MacDonald, a barrister at Essex Court Chambers in London and a fellow at All Souls College in Oxford.
We are fortunate today to have a very special episode dedicated to the advisory opinion on climate change, which was delivered unanimously by the International Court of Justice on July 23rd. We are recording a couple of days after this extraordinary and historic opinion, and we are excited to have a panel of experts joining us today to discuss some of the main highlights and most important conclusions of the advisory opinion. They are Lavanya Rajamani, Nilüfer, Andrew Loewenstein, and Franz Perrez. They're all experts in international law and international environmental law especially, and they all have participated in the advisory opinion representing different actors. I would like to ask each of them to introduce themselves first and to tell us how they have been involved in the case. Lavanya, can I start from you?
Thank you, Chiara and Alison. I hold a professorship in international environmental law at the law faculty at Oxford. I specialize in international climate change law. Over the years, I've worked in various capacities, closely in relation to the climate change negotiations, including as part of the UNFCCC core drafting and advisory team for the Paris Agreement. I acted as coordinating lead author for the IPCC's sixth assessment report, which the advisory opinion refers to extensively. And I've had the huge privilege to act as counsel for Vanuatu in the advisory proceedings before the ICJ.
Thank you, Lavanya. Franz?
Thanks. First, thank you, Chiara and Alison, for inviting me to this broadcast. I'm the legal advisor of Switzerland, so heading the Directorate of Public International Law in the Swiss Foreign Ministry, and I'm also teaching international environmental law at the University of Bern School of Law. With regard to my involvement in that case, I was first involved as Switzerland's lead negotiator when we had to decide whether Switzerland should co-sponsor and support the request for the advisory opinion, which we finally did. And then I had the privilege to prepare together with my team the Swiss submissions to the court and was also acting as counsel in all the proceedings.
Thank you. Nilüfer?
Yes, thank you so much to Chiara and Alison for inviting me to join this stellar panel of experts. So I'm director of the Center for International Law at the National University of Singapore. And my involvement in the advisory opinion, actually there's two parts. One part, I was part of the legal team for the IUCN, the International Union for Conservation of Nature, in preparing the written statement. And not everyone may be aware, but the IUCN is actually an intergovernmental organization. So the court had invited it to also both submit written statement and also oral arguments. However, I also had the tremendous privilege and honor to be invited to join the Palestinian delegation for oral arguments where we presented something that no one else raised, but and that had to do with conflict and occupation and the impact it has on climate change and greenhouse gas emissions.
Thank you. Andrew?
Thank you, Chiara and Alison. I'm Andrew Loewenstein. I am a partner with the law firm of Foley, Hoag in Boston, where I practice with the firm's international litigation and arbitration practice. My practice focuses on public international law and litigation before international courts and tribunals. I have been involved in a number of international environmental law cases over the years, including the Pulp Mills case, where I acted for Uruguay, the joint San Juan River cases, where I acted for Nicaragua, and also the MPA arbitration, where I acted for Mauritius. My involvement in the climate change advisory opinion concerned representing a number of African states, including Sierra Leone, Namibia, and Gambia at the ICJ, and before that, acting for Sierra Leone and Mozambique at the parallel advisory opinion proceeding before ILOS.
What an incredible panel of experts. Thank you so much for joining us. And Alison, you have also worked on many climate change related cases, and notably at the European Court of Human Rights. May I ask you to also briefly tell us about your involvement?
Yes, so I've advised states on the present advisory opinion proceedings, but I also come at it from, I was picking up in the EO the references to intergenerational justice, particularly because I've had the wonderful privilege of representing a number of children and young people before the European Court of Human Rights and the Inter-American Court of Human Rights. So I particularly was interested in the human rights aspect of the AO.
Wonderful. Thank you. Thank you. I also had the really great privilege to participate in the advisory opinion and acted on behalf of the African Union, which, as our listeners probably know, is an international organization which represents 55 African states. Before we start with the discussion on the advisory opinion itself, I'd like to give our listeners a very, very brief background on the opinion, which came from a request by the General Assembly in Resolution 77 to 276 of March 2023, with just two very specific questions, very important ones. A, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And B, what are the legal consequences under these obligations for states where they, by their acts or omissions, have caused significant harm to the climate system and other parts of the environment? With respect to two sub-questions to states, including in particular small islands, developing states, which due to their geographical circumstances and local and level of development are injured or especially affected by or particularly vulnerable to the adverse effect of climate change, and then two, peoples and individuals of the present and future generations affected by the adverse effect of climate change. Now, let us start with the first topic they would like to delve in. Given the magnitude of this opinion and how consequential it will be, we thought we will do things a little different this time in this episode and discuss with our guests the specific topics. And the first topic would be the sources of law. Here, I thought the International Court of Justice made some significant conclusions on the applicable law on climate change. First, it focused on the most directly relevant treaty law, including environmental law as it was directed, but not only the UNFCCC, but also subsequent provision, and also UNCLOS, the Ozone Layer Convention, Biodiversity Convention, and human rights law. It also talked about customary law in a lot of very specific details, and it found that the duty to prevent significant harm and duty to cooperate to protect the environment apply also to climate change, and really painted a picture of a coherent legal system where the sources interact, and concluded differently from what had been asked, for example, by the US and Japan, that climate change was not lex specialis because there was no inconsistency between the different sources and there was no discernible intention that one provision would exclude the other. And I think this is quite interesting. It repeatedly said about, these norms inform one another. So let's open this for discussion. And Franz, starting from you. I know differentiation and different obligations of states was something that was at the core of your pleading. What do you think of what the court said in this specific issue?
Identifying the different sources of law is one thing. Clarifying how they apply to the different states is something else. Differentiation between the states is one of the most controversial issues in climate change law and policy. Some of the world's biggest emitters with significant capacities, like China or Saudi Arabia, argued that there are two fixed categories of developed and developing countries based on the annexes of the UNFCCC adopted in the last millennium and also reflecting the reality of the last millennium. And based on this, they have claimed that because of their status as developing countries, they have basically the same legal obligations and responsibilities as the other developing countries such as Tuvalu or Senegal. The ICJ has clearly rejected this view. It stated in several places that not only historic responsibilities, by the way, without going into the details when this responsibility started, so it not only stated in several places that not only the historic responsibility, but also current responsibilities and current capacities and current national circumstances determine the standard of differentiation and due diligence. In paragraph 226, it explicitly said that, quote, the status of a state as developed or developing country is not static. It depends on an assessment of current circumstances in the state or concerned. End of quote. And in paragraph 2090, it holds that the capabilities of a state are a key factor for the determination of the applicable standard of due diligence. I think the fact that the ICJ really places the focus on the current capabilities is really relevant. That the fact that countries that belong today to the biggest emitters and do have a significant capacities that they can no longer hide behind their status as developing country is really an important outcome of this advice opinion.
Thank you very much, Franz. This is very interesting. Let me ask also, let's hear what the other guests think about these issues, and most significant maybe on issue of sources. Nilüfer, I think that you pointed out also the issue of the legal status of decision by the COP. Can you tell us a little bit about that, or maybe something else that you found also of interest on the specific issues of this topic of sources?
Yeah, thank you. Thank you so much. It really, I have to say, we all listened intently for 2 hours as Judge Iwasawa had the very challenging task of reading that opinion. And it seemed like every sentence, you could almost hear a gasp. Oh, and so the sources of law certainly was fascinating. And one of them, I have to add, I was I found very important that the court treated the 3 climate change instruments, the trilogy, as in a very integrated manner. And we can add to that now, of course, the COP decisions as well. And so I'm just going to focus a little bit on specifically the position that the opinion took on COP decisions. For those, I think everyone's been involved one way or the other in Conference of the Parties, Meeting of the Parties, Conference of the Meeting of the Parties. There's different acronyms to it. And Franz is very modest. He was for many years the lead negotiation for Switzerland, very active. I also at that time for some years was with the Turkish delegation. Of course, we won't talk about differentiation on that. So, and we all know the amount of time it goes into negotiating these COP decisions. And I think overall, it was never that clear what the status of the COP decisions were, whether these are just political statements, not binding. This was something for debate. Now the court has taken a position that there may be instances where the COP decisions are legally binding sources, we can say. And they specifically made reference to, well, if the treaty so provides, and then gave the example of Article 4 as an example of Article 4, how, the obligations to report as decided by, this is a Paris Agreement, making specific reference to a COP decision of the Paris Agreement. But it didn't really limit it just to that. So I'm very curious to see how this part of it will resonate in future meetings. And I have to say one thing, the opinion also made reference, of course, to Vienna Convention on Law of Treaties, subsequent agreement, subsequent practice. And I think that's where it really opens the door to how these COP decisions will be used in the future. And one footnote, of course, one of the members of the court, former member of the International Law Commission, was also the special rapporteur for that very topic on subsequent agreement, subsequent practice. That is Judge Georg Nolte. And so there's express reference to that. So it's interesting how the COPs will go in. And if I can just add, and I'll end here, I was really taken by Kyoto. Kyoto was resuscitated. And so we'll see. Very interesting, but I'll stop here. Thank you.
Thank you. Very interesting indeed. Lavanya, I see you nodding on video. Can I ask you also what you think? Do you agree with Nilüfer? Would you like to also tell us what you think on this topic of human rights or anything?
Obviously, I very much agree with Nilüfer and Franz. I think with Nilüfer in particular on the fact that Kyoto was resurrected in this context, which was interesting to see for those of us who are sort of diehard Kyoto fans, having seen a sort of international instrument which is prescriptive, has obligations of result, has a compliance system, with sort of penalties for non-compliance. This is, but which of course was politically unpalatable. And so has died a natural death in some respects, at least politically. It's interesting to see that it still has legal significance. So that was an interesting sort of element, I think, for many of us. I actually wanted to pick up on one of the other issues that you raised, Chiara, which I think is perhaps one of the most significant aspects of this opinion. And it is an overarching, cross-cutting message that flows from this advisory opinion, which is that the Paris Agreement needs to be interpreted in its normative environment. And that international law is a sort of seamless web of interlocking obligations, treaty, custom, principles, and standards. And interestingly, standards, not just binding standards, but also non-binding standards, which I thought was also very significant. And that the Paris Agreement cannot be interpreted in the atomistic fashion that some of the major emitters had argued it should be interpreted. This, to me, represents a much more progressive, emancipatory, fit-for-purpose vision of international law than one that is solely and narrowly reliant on state consent and atomistic interpretations of particular treaties such as the Paris Agreement. So I think this interpretative approach, which runs through the entire opinion, has resulted in very robust and muscular interpretations of provisions of the Paris Agreement, which I know we will come to, but also to very intuitive interpretations of the customary principle of harm prevention and cooperation, for instance. And it would be helpful, perhaps, in that context, it would have been helpful to have seen a little bit more discussion on, for instance, the state practice and opinio juris in relation to the harm prevention principle extending beyond the bilateral cross-border context to issues affecting global commons. But at least it did assert that it sort of extended beyond sort of the cross-border context. It would have been helpful to see some more explanation of that. I found the discussion on the right to a healthy environment, which you raised, was interesting, but ultimately somewhat unsatisfying because the court found that the right to healthy environment was essential for the achievement of other human rights, but it stopped short of actually characterizing it as custom and led to some ambiguity on that. And I can see why it fell short of that, but it also fell short in some respects of elaborating core operationalizable content for this right. And some of the separate opinions and declarations did actually mind this theme. So Judge Bandari, for instance, interprets the court's opinion as implicitly finding the right to healthy environment as custom. Judge Erescu sort of argues that the right to healthy environment is custom. And Judge Charlesworth did elaborate on the content of the right to a healthy environment without explicitly characterizing it as custom. So there is some ambiguity here in the opinion itself on whether the right to a healthy environment is custom and what its core operationalizable content is. So as I said at the start, I think perhaps the most significant element of this opinion to me is that the Paris Agreement has to be interpreted in its normative environment, and it represents a much more fit-for-purpose vision of international law. However, I think in terms of the content of some of the elements in relation to sources of law, more could have been done to make it operationalizable, perhaps. Thank you.
Thank you very much, Lavanya. I agree. It's interesting that you raised also the separate opinions, because of course this court was a unanimous decision, but it seems that in some instances, some of the judges in the separate opinion raised issues they may have gone even further than what they've done, but they certainly paint a picture of harmonization rather than fragmentation, which I think will be very helpful. Saying, however, that sometimes there's a general discussion rather than saying, well, states then more specific have to look at it. Andrew, you represented several states, as you mentioned, during the advisory opinion. What is your opinion on these issues? What are your thoughts?
Well, I completely agree with the notion that the court resisted the temptation to try to interpret the relevant treaties in an atomized fashion. that instead it really took the opposite approach and interpreted them as a coherent whole, but importantly, interpreted them in light of various principles that it emphasized. And those included the CBDR, RC principle, sustainable development, equity, and the precautionary approach, which I think, assisted the court in devising an interpretation of the treaties consistent with broader customary international law principles that resulted in a single coherent set of obligations, which ultimately will be of assistance to states in figuring out how to concretely implement the principles that the court articulated in its opinion.
Well, thank you to Andrew for that. I think that's been a really helpful overview on the sources as the courts found them. So the sort of legal landscape, the network of obligations that states have. And I want to move, after setting the scene in that way, I want to move from the sources to the content of the obligations that those sources impose on states, because the court reached some very significant conclusions when it was addressing the issues of liability, attribution, scientific knowledge. And to take an example, in relation to the specific obligations under the Paris Agreement, it found that member states had specific obligations relating to mitigation, adaptation, finance, technology development and transfer, and it specifically addressed the issue of the 1.5 degree target, which the parties to the UNCCC agreed as a goal for limiting the global average temperature increase. It also found that states can be individually liable for the effects of their climate change emissions. So paragraph 427, for example, it says that failure of a state to take appropriate action to protect the climate system from GHG emissions, including from fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act which is attributable to that state. And I, for one, my highlighter absolutely stopped and highlighted that paragraph when I first was able to see the printed text of the advisory opinion. Now, Lavanya, I wonder if we can start with you this time. What do you think was particularly significant in this part of the court's opinion?
Thank you, Alison. While your highlighter obviously sort of lingered over paragraph 427 when you read the opinion, I think for those of us who were in court, our jaws dropped when that paragraph was read out. I think sort of going back to sort of the broader question about the most significant aspect of the opinion in this context, I would say the singular sort of element to me that came through is that national discretion is not unfettered. I think, stepping back and looking at the Paris Agreement framework, one of the most glaring weaknesses in it, and of course, this is a weakness that's been deliberately negotiated in by states in a consensus-based process, but one of the most glaring weaknesses is that the content of the nationally determined contributions that states put forward is not subject to any adequacy or fairness assessments. And I mean individual assessments of each of those NDCs. And this has proven to be a real stumbling block to making national actions add up to 1.5 degrees centigrade or well below 2 degrees centigrade, and to ensure that states are actually doing their fair share. The 2023 UAE consensus even contained a recital in that decision that stressed the nationally determined character of nationally determined contributions, where it was highlighting the nationally determined nature of those contributions. That's how hardwired national determination is in the Paris Agreement negotiations. The ICJ, however, refreshingly and robustly found that discretion of states in relation to the content of their NDCs is fettered by the 1.5 degree temperature target. And this goes back to sort of Nilüfer's point on COP decisions, because it sort of landed on 1.5 degrees because of subsequent COP decisions that sort of stressed the importance of 1.5 degrees, a subsequent agreement that sort of interpreted and sort of fine-tuned Article 2, which actually stresses well below 2 degrees centigrade and makes 1.5 degrees tad more aspirational. It has also fettered national discretion by the requirements of progression in highest possible ambition in Article 4.3, which it fleshed out in general terms. and by the standard of due diligence, which it also fleshed out and identified as objective and stringent in line with the ITLOS advisory opinion. I think, however, the court could have done more in relation to how all of this can be operationalized. And I feel, dreadfully greedy in saying this because everything that we got from this opinion was far beyond what we could have expected going into it. But however, one has to be ambitious. I think the court could have done more in terms of how it could be operationalized, especially with regard to CBDR and fair share, which of course is not a term that it actually uses, but is sort of common in the scholarship and thinking around this. It doesn't actually elaborate on that. And in fact, when it sort of looks at Article 4.3, it only addresses 2 of the 3 elements of Article 4.3, which is progression and highest possible ambition, doesn't sort of flesh out common but differentiated responsibilities and respective capabilities in this context of how nationally determined contributions are to be fettered. It doesn't actually sort of tell us what mechanisms in the climate process can actually be used to help assess the content of the nationally determined contributions. And in relation to the sort of finding on fossil fuels that you read out, Alice, in paragraph 427, how is this actually to be operationalized? It is a sort of sweeping and ambitious sort of requirement and very much in line with what we need if we have to transition to a beyond carbon economy and transition to a climate safe planet. We have, $7 trillion being spent on fossil fuel subsidies today, and we can't address this problem without addressing all of these elements of it. However, how is this actually going to be operationalized? So some nuancing and fleshing out of this would have been helpful. And we see this in the declaration by Judges Bandari and Cleveland, for instance, where in the context of the due diligence obligation, they argue that environmental impact assessments should include Scope 3 emissions, and they discuss the importance of CBDR in this context. But of course, they also note that CBDR shouldn't be a get-out-of-jail-free card, which I think is in line with the comments that Franz made earlier as well. It would have been good to have seen a little bit more flesh on the bones on this issue in the opinion, but overall, again, national discretion is fettered, another central message coming out of this opinion. Thank you.
Yeah, I think, I completely agree about the open questions that are left about operationalizing this. And I'm, around the world from the minute that the reading finished last week, tremendous amount of thought will be going on, is going on as to, what are the next steps? Because this is clearly a beginning from this rather than an end in terms of how you make the statements of principle bite on states. Nilüfer, what would you pick out from on this aspect of the advisory opinion?
Yeah, thank you. Thank you. Yeah, I think Lavanya just said it so well. And I agree with everything she said. For those who have been, working in the climate change sphere, and often you would hear the comment, oh, Paris is just a soft instrument. But it's not now. I can say that. That, I think, is what's so remarkable, how this opinion has really fashioned Paris into, and it was, they were always there, to be quite honest, but now when you have, the World Court stating this, that there are hard obligations under Paris, and the point about that the discretion that states have is quite limited, may come as a shock to states, frankly, because that was how the Paris Agreement was negotiated. This whole idea of bottom up, self-determination, making your own self-distinction and obligations and mitigations. But the reality, and I think that's it, the court has seen the reality. Having said that, one thing I want to add is I felt that in looking over the opinion, the Compliance Committee was given a boost in this opinion. And I say that because it hasn't made necessarily reference directly, although there was, I think, one reference to the committee, But in terms of, there was one part in the opinion in that the assessment of due diligence obligations, and again, now the due diligence obligations is somewhat integrated with many other different instruments, could be COP decisions, but that this was an issue for the compliance in the assessment of the compliance. I did have it. I don't have it in front of me right now, but I thought, compliance committee. I can see from this opinion that there's going to be even more I don't want to say importance, but much more work ahead for the compliance committee. They've been given a boost in this. And so I think that we have here, yes, we could have had more. Yes, we don't. I agree not wanting to be greedy. But I think this is really a very significant opinion, and we will keep talking about it for a long time. There's much more I can say, but I don't want to take all the time, so I'll stop here.
I think that's very interesting, Nilüfer. We've seen, in the human rights courts as well, we've seen states say Paris, all of our obligations are in Paris, and they're just not hard-edged. They're very flexible, and it's up to us to decide. So I think that open-textured nature of Paris has been really put to bed by the court. I think to me, that's very significant. Andrew, what would you pick out from this sort of aspect of the opinion?
But really, it's two themes that I thought ran throughout this section of the opinion. The first of which was mentioned earlier is the limitation on discretion, which was something that the court emphasized in a number of occasions. But what made that emphasis on the limitation on discretion particularly significant was it was paired with the repeated invocation of the fact that states are internationally responsible if they don't respect the limitations on their discretion. And that, I thought, was a very powerful message to states, that these are obligations that are not just hard obligations that you must comply with, but if you don't comply with them, then you face international liability. And then this is jumping ahead, but the liability that states face is of an ergas omnes partes, or ergas omnes nature. And so that any state can bring a claim against any other state that exceeds the limitations on its discretion. So that is, I thought, a very robust position for the court to take, that sends a very strong message to states, both in terms of their behavior, but how they operate in the forthcoming negotiations on these issues.
Yeah, so there's a real stick alongside the carrot of wanting to do good, but there's a real potential stick, and I know Chiara is going to have some questions about that.
Right,
shortly.
And just to further elaborate a little bit more, this appears to be a trend, because one of the very interesting aspects of the ITLOS advisory opinion was the fact that although the tribunal was not asked to express a view on state responsibility, it nonetheless went out on a limb and said that states bear international responsibility for the breach of the obligations explained in the opinion.
Yeah, so sorry, Franz, I was going to turn to you right now, so please do.
Sorry, because on the one side I fully agree with what Nilüfer, Lavanya, and also Andrew just have been said, but on the other side, I think Lavanya was hinting at that. Sometimes when we then look into the details of advisory opinion, then the really important elements are missing. And therefore, I think we should not perhaps be over optimistic of the direct impact of that advisory opinion. With regard to CBDR, for example, as indicated, it refers to the current capabilities. It refers that you have to take into account about available scientific knowledge about new technologies. So that gives a clear guidance that the bifurcated approach doesn't work anymore. But then the court does not make the step, as Lavanya said, to really start to say, well, from when on is, for example, the fair share not anymore a perfect share? For when on is a burden share not anymore a fair one? And I think that is linked to the fact that the court clearly said that it is not determining the legal responsibilities of individual states or group of states, but only of the responsibilities in general, and that it is setting out only the general legal framework that governs responsibilities. And it also said several times that the determination of the responsibility of an individual state would require an in concreto assessment in a case-by-case basis. And then the needed instruments for that in concreto assessment are missing. Let me just pick up, for example, that discretion on the NDC. That was indeed, I think, tremendous to see that there is not a discretion in just determining what the NDC is. Something which we during the negotiation argued repeatedly. We were already rejected with our argument. We then tried to sneak in this limitation discretion by requiring states to inform the others how they think that their NDC is respecting a fair share. So we tried to bring that in, and the court was picking that up, and that was great, I think. And I think that is a robust analysis. We can make that analysis. Although, to be honest, I think that was what Nilüfer said. States, when agreeing on that, didn't think of that. I think that is clearly going beyond their state intention. However, by just saying that the NDCs, the discretion is limited because the NDC has to reflect the highest possible ambition, then I think that comes to an end when it does not say what means highest possible ambition. Is the highest possible ambition defined through the technology that is available, through the feasibility, through social elements, the political elements, economic elements? For example, if the Swiss population rejected in a democratic process an ambitious CO2 legislation because it felt that this legislation is too ambitious, and then adopted later a less stringent CO2 legislation, does that mean that this less stringent CO2 legislation is reflecting the highest possible ambition of Switzerland? So by not giving further guidance what possible means, I think this decision misses an important point. I would like perhaps later to come back on the relationship between the due diligence obligations and the obligation of the climate law, because there I thought the court also made quite an interesting step.
Chiara, I think I'm going to hand back to you now after looking at that whistle-stop tour of many other aspects of the contents of the obligations that we could delve into. But I want to save time for you to have a bit of a look at the consequences as the court mapped them out for states from falling short of their obligations.
Yeah. Well, thank you very much, Alison, and thank you all. I really wish we could talk for much longer, but I just wanted to approach the issues that you've all hinted to it. What are the legal consequences, right? We have these decisions and the obligations and this incredible decision of the court that said that some emissions will have some consequences, and the court was specifically asked to look at the legal consequences also. And I was particularly struck by how the court looked at the legal consequences arising from state acts and omission that cause a significant harm. And this is something that I worked on very closely with the African Union, and I find very important. So in particularly, I thought the fact that the court specifically said that the entire framework of state responsibility was applicable to climate change was particularly relevant. And the court concluded that the rules of state responsibility were capable of addressing the situation even when damage is caused by multiple states, and that it may require states to invoke responsibility separately needed, as we mentioned already, in concreto assessment, and within the usual standard of sufficiently direct and contained and certain causal nexus. Maybe, as we said, also opening for future litigation. This has received a lot of highlight also in the commentators saying, so what is the next step? Is it the court calling for possibly future litigation? And two conclusions were particularly important, I thought, to me. One is that the obligations of protecting the climate system and other parts of the environment from anthropogenic greenhouse gases are erga omnes obligation. And second, that there's a duty to make reparations through restitution and integrum, again, the entire spectrum of state responsibility. So restitution, compensation, and satisfaction. And at paragraph 454, the court opined that compensation can be given in the form of a global sum, also looking back at its own jurisprudence, where there's uncertainty with respect to the total damage caused and taking into account equitable consideration, we can think about a global sum. So what do you all think about these conclusions? Did the court go far enough? How are we operationalize this global sum? Andrew, can I start from you this time?
Sure. So I would not say that the court didn't go far enough. I think the court was met with a challenge, which is you have what is on the plane of state responsibility. It is an inherently case by case inquiry, and so it's very difficult for a court to express in theoretical abstract terms anything beyond what it already said, which is that the broad principles of state responsibility apply with full force to state responsibility in the context of climate change. One of the things I was a little concerned about was that the court would close the door to some aspects of state responsibility. But it didn't do that. In fact, it took the opposite approach and said quite clearly that effectively all options are on the table when it comes to issues of reparation and compensation in this particular context, and that whether the requirements are satisfied in any specific case need to be dealt with in an concreto fashion, but that all options are on the table.
Thank you, Andrew. Franz, what is your view on this? Do you have any thoughts?
I think that was very well put by Andrew. The court did not close the door, and some states in intervening wanted to close the door. I think that is the progressive element, but it did not really indicate, because that door was available already before, and it didn't give any additional criteria how this door should be used. So it didn't give the key for the door, because it just said in paragraph 431 that each injured state may separately invoke the responsibility of every state which has committed an international wrongful act resulting in damage to the climate system. If you read the court advisory opinion carefully, then probably each state is not complying with its primary obligations, as outlined very ambitiously by the court. But would that mean now that states easily could go in and for example, that European countries that currently suffer from forest fire because of climate change, that they now would just go after China and Egypt and asking them for compensation because of their responsibility? I think that is an important point. The court did not say there's a responsibility only in one direction. It said it's going in each direction. And it even has stated that the states most vulnerable and the most fragile states and most exposed states do not have additional reparation rights than the others. So from that perspective, I would say it was rather conservative. But then if you would have to prove the damage, the causation damage, that is very difficult. First of all, you still need to show that damage is caused by climate change and not by your own failure. Is the wrong forest management policy responsible for the forest fires? When a flood is destroying infrastructure, is that because the mangrove forest has been destroyed or not? So you need, first of all, to get over that step. And then secondly, the court does not indicate from when on you are just violating your due diligence obligations. So you'd have to, in each specific case, you have to show China or Switzerland is because of that specific measure, it is breaching its violations, and this breach has led to so-called illegal emissions, because some part of the emissions will still be legal. And Switzerland or China will only be responsible for that illegal part of these emissions. So all these very complicated assessments, there the court doesn't give any guidance. Therefore, I have the impression this might look much nicer than it is at the end. The decision is just repeating what we all knew before. But, and I think that's an important point Andrew made, it did not close the door.
Thank you, Franz. Lavanya, what do you think? Did he open the door, but then just a little bit? Or what did the court say? We didn't really talk very much about attribution, but what is your view on this issue?
Thank you, Chiara. Very much in line with what both Franz and Andrew have said, actually. The court could not have gone any further than it did. And in fact, I'm sort of pleasantly surprised that it went as far as it did. I think in the early years, we believed that negotiations were our only option to solve this problem. And we were convinced that evidentiary challenges and legal doctrine would be insurmountable. But initially, national, regional courts have been chipping away at this, and now the ICJ. And I think this is very significant. And this is the section of the advisory opinion that will cause the most upset amongst the major emitters, right? The courts discuss it in very general terms, and that's all it could do. And it did, in theory, clear the way for claims to be brought. And I think in line with what Franz was saying, in concreto assessments are going to be incredibly difficult, though. Even if they're not impossible, they're going to be incredibly difficult. And if I could just pick up on one aspect of this, which is the science, even the science that needs to be used will be contentious. So the advisory opinion suggested that, science has potential sort of relevance here, and it could, these things are not impossible to do. But what science are they going to rely on? So the advisory opinion and the Inter-American Court, for instance, only relied on IPCC science, right? And of course, the IPCC science is sort of seemingly consensual science. It's the most sort of well-accepted science. But the IPCC science, first of all, will always be dated, as it is the process of reviewing the literature and distilling it that takes about 5 years to happen. So it's never going to be the most current science that you can use. And IPCC science will not be prescriptive because especially the summary for policymakers are negotiated documents. And the concerns of states, including concerns about liability and compensation, will frame how some of these are sort of posited in, especially the summary for policymakers. So what is the science that's going to be used to provide sort of evidence on these matters, right? So coming back to the point that Franz was making also, in concreto assessments are going to be incredibly hard. So while it is great that the door has been left open on state responsibility, I think it's going to be a challenge to actually make any of these any major emitters actually accountable in the ways that one would envision in this context. But having said that, we didn't think an advisory opinion of this sort would be possible 5 years ago, and this is sort of far beyond the reach of what most felt we would have. And so maybe there's hope, even in the context of a contentious case, that we would be able to sort of jump all these sort of roadblocks along the way in terms of evidence.
Thank you very much. Nilüfer, would you like to chime in on this issue?
Yeah, well, of course, I couldn't agree more with all my distinguished panelists on their comments. I just wanted to add that one of the first headlines that came out after the reading of the advisory opinion was why BBC states can now sue each other. So clearly, they read it to be that the door had been opened quite a bit. But I think the door has been opened. There's no doubt about that. And I think the expectation that the court could, give us a guideline and a map as to how to do it, how it would be done, is probably not realistic. It's already 200-page or more, I think, opinion. But most importantly, they made very clear that the states are responsible, and there are all the articles of state responsibility apply in toto. Two things. One, I wanted to add, one aspect, and this had to do, we haven't touched upon, and it's relevant to this issue, is this notion of specially affected states. And in that sense, the court said, there's no distinction made in the articles of state responsibility. They're all treated the same. So in that way, this notion that the specially affected states may have some special standing in the legal consequences, that door seems to be closed. That's something to look at. Although I think they try to open it in other ways. We are looking, because we're lawyers, we're looking at, legal consequences. That was one of the issues. But one thing not to overlook, because ultimately, if the underlying goal is to get assistance for those specially affected states, for those most vulnerable, who are being disproportionately impacted by the consequences of climate change, the court made very clear the obligations to cooperate, financial assistance, technology transfer, which, these, maybe we should be really focusing more on how we can build, instead of how we can sue and try and get reparation, which of course I understand the importance, but court really did make that very, very clear. And we need to work on that. And just last, of course, we had one comment on sea level rise, which is very important because states who are losing the small island states in particular, there needs to be, by the time you go to court, you sue, maybe it's too late. We really need to be giving the much needed financial assistance, technology assistance, and other forms of cooperation to alleviate the very disastrous consequences of climate change for these states. So I'll end here.
Well, I'm going to wrap up in a moment, but I think firstly what would be really nice is for each of you to just maybe in a minute or so just wrap up what you see as the significance of this opinion. Obviously, we're all still digesting, but final words. I'm going to invite them in the opposite order to the answers we just had for the last question. So I'm going to invite Nilüfer, Lavanya, Franz, and finally Andrew for just a final wrap-up thought or reflection.
Well, it's very hard to wrap up in very short words because it is truly a landmark, monumental, historical opinion, and we're still digesting it. There's much more to go through, but I really commend this court for going beyond what many expected. And I think we have to be careful not to, is the glass half empty, half full? So I think it's a great opinion. And I know we will be working on this for much more time to come. So thank you again for inviting me to this panel.
Lavanya?
Thanks, Alison. Of course, very much agree with Nilüfer. She has used up all the adjectives, though. So that's
Yes. There's only so many times you can say historic and landmark.
and monumental. But having said that, I think this opinion sort of reasserts and reinforces the central importance of international law in addressing global existential civilizational challenges. And I think there were question marks around this in the context of climate change, whether international law, given the limits that we've seen within the treaty context, was going to sort of be sufficiently nimble to address this issue. And I think this opinion suggests and sort of reinforces that it is sufficiently nimble, dynamic, and can evolve to address civilizational challenges. And I think that's a central message that I'm going to take away from this opinion. Whether this maps onto the reality of geopolitics is, of course, an open question, and that's what we're going to have to see in time to come.
Franz, any final thoughts from you?
Thanks. First of all, I would be cautious with terms like monumental and so on, because at the end, the decision is not as specific as you might have needed in some very important issue. And the court itself, actually, interesting, in the last paragraph, it says that international law has an important but limited role in resolving the problem. I think we have to be aware of that. But the two most important issues from that decisions, from that advice opinion is, first, as indicated, differentiation. It made really clear a bifurcated approach doesn't work anymore. And that is important because climate change cannot be solved when looking at the reality of the last millennium. So I think that was really important. That will have an impact on the negotiations. And then secondly, what was a surprise to me was how it has fleshed out the Paris Agreement and brought in the substance of the commitments and obligations, responsibilities into the Paris Agreement. We were arguing the substance into the due diligence obligations and were bringing it through that into the obligations of the states. But the court did it differently. It introduced it through the Paris Agreement. And I think that is also quite promising. And I think one of the best outcomes would be not if that would now trigger responsibility claims and claims for damage compensation, but that the consequence would be that states now really take these obligations more seriously, because at the end, what is needed is more mitigation action, more cooperation in order to adapt. That is much more important than compensation for damages at the end.
Andrew, the last word.
So I do agree that this is a landmark historical opinion, but what's also interesting is that at bottom, the court was really simply applying generally understood principles of international law to the context of climate change. And the result is what the result is. And that's effectively what the court was saying. Something else that I thought permeated the court's discussion, even though it didn't say this expressly, although it came close at the end, as Franz pointed out, is that this is an opinion that is meant to be used. After all, it's an opinion that was requested by the General Assembly for the purpose of furthering the General Assembly's work and furthering the work of individual states. And I think that throughout the opinion, the court really had that in mind. And that now it's up to the General Assembly and states and their multilateral and bilateral relations to implement the legal obligations that the court has explained in so clear and unmistakable terms.
Yeah, and indeed, the court in its very last paragraph talks about itself as forming part of the work of the United Nations. So it's very much seeing this as it's not seeing itself as the one solution to the problem. It's very much situating itself within the UN framework. And I think that's a very interesting way for it to have ended. It's 456 paragraphs just to say basically, over to you, states, again. Well, thank you so much to everybody across a range of time zones for taking the time to join us today, being so generous and thoughtful in sharing your insights on the court's advisory opinion, historic or monumental, or whichever adjective you choose to call it. I think it's all of these things. I know that Chiara and I have really enjoyed our conversation, and if our listeners have too, you can join us on the first Monday of every month for more international law chats.